So I'd like to know what Justice Department officials have been doing to ensure that there is not an issue or that it can be dealt with quickly, because that has been the whole point of what has been taking place here for the last couple of months. So I listened to. I would like to have someone from from Justice be able to enlighten me on that.
Yeah, thank you for the question. I work for NRCan Legal Services, not the Department of Environment. So what we're proposing here is to create a distinct date for the coming into force of paragraph 9.1 in the section, 119, so that when the Minister of Environment is ready to introduce the revision to the IAA, will be able to bring into force this provision at a distinct time without slowing down the coming into force of all other provision proposed in C-49.
So therefore there is an admission that there is a conflict between the Impact Assessment Act and the unconstitutionality that has been presented and this legislation. I just want to make sure that, because you are carving out portions, and I'm sure that, if we go to any of these, that would be a similar answer, that we have to change this one because we are awaiting the ministry or the department excuse me, trying to sort that out. Is there, and I guess this is a concern that I've had over the years. We do have lawyers in departments. We have there should be decisions made that doesn't make it constitutional. However, we have other courts, Supreme Courts and others, that will say no. There's a problem. It has to be fixed. What is the reason why you weren't able to give information about the fix earlier on? Or we simply have to wait and assume that the minister will come up with the proper type of discussion of legislation to fix it? And how will we know that it actually does fix it? I mean, it will be a bunch of legal people from your team that will say, okay, we believe this is a fix. Is it going to go back to the Supreme Court then to see whether, in effect, it does remedy the concerns? How will we know?
The only answer I can provide you at this time is that we introduced C-49 before in May 30, and as my colleagues from the legislative sections are working on a revision of the IAA, we've been asked to make a few amendments to this bill to ensure that we will bring these provisions only in force once the revision of the IAA has been done. So
So the suggestions that we've been making that indicates that maybe C-49 could have been looked at later, once you have had all of that done, would have some merit?
This is not for...
But would it have been easier had you not having to be dealing with this legislation if you had some certainty on how the government was going to deal with the unconstitutionality aspect of C-69? Would it have been easier? No, this is the reason we're
Um, the discussion, as you know, the Accord Acts are joint legislation that we jointly manage the resources with the provinces, and the agreement between the federal government and the provincial government here was to bring forward C-49 with the proposed amendments and the motions to be able to carry on the work on C-49. And that's how far I can answer to your
Okay,
question.
well, thank you. And my main question was on timing, as to whether or not there had to be this rush to be able to get that done until we'd had sorted out what the other problem was. So I leave it at that.
Thank you, Mr. Dreeshen. I'll now go to Mr. Bruson.
Maybe just to follow up with the officials on that, I was just wondering if you could advise of if the provinces support the amendments.
Yes, the provinces have been consulted on the amendments and the motions, and they support what is being proposed here.
Okay, thank you.
Okay, thank you. Oh, no problem. Go ahead, Mr. Patzer.
Is this like a standard procedure? Like, I understand you're trying to leave a room for them to make the amendments to the unconstitutional parts here, but is this the wording here? Is this the standard procedure to create that wiggle room for them to be able to do that? Or is this something that's going to have to come back to committee after those proposals are done for us to revisit at a later date?
Well, the wording here is what we need to create a distinct date for coming into force of the provisions, and if there are further amendments that are required, this will be addressed when we see what the IAA revision bill will propose if necessary.
Okay, so this is okay but without a distinct date, like that was kind of my point of my first question earlier, was the fact that there isn't a distinct date, but you said this is common language to create that room to be able to retroactively put in a distinct date after the fact. Like, is that like this is standard? This is regular. This happens all the time. Is that what I'm to believe here?
That's what we have to insert into the bill to create separate clauses.
Okay. Is there okay? But you guys don't have a date in mind here yet, then, obviously.
There's no set date. Clause 221 of the bill simply have a date of coming into force by order of the Governing Council for the different provisions. That's,
okay. Thank you.
Okay, do we have any other speakers? Ms. Tubbs, go ahead.
Well, Chair, I would just say, I think we feel for the position that the officials are in. It's blindingly clear that the Liberals' failure to bring in changes to remedy the Supreme Court's decision that less than 10% of the Impact Assessment Act is in fact constitutional. The Supreme Court said, quote, unquote, largely unconstitutional, even though that bill has been law for the last 5 years, and I can say personally, and on behalf of my Conservative colleagues, nearly every single issue the Supreme Court of Canada pointed out as a problem in the Impact Assessment Act, we pointed out during the debates on C-69. In fact, it happened to be me personally often in the debates on C-69 through committee and through each stage. So, good kudos to the officials for doing their best in this position that unfortunately the elected members of Parliament have caused for them. I would just note, of course, that it's been 139 days since the Supreme Court said that the Impact Assessment Act, including all of the provisions that are here in C-49 relating to decision-making power and to the project scheme are all unconstitutional. This is, of course, why, Chair, you'll recall that I moved a motion which was rejected by the NDP Liberal Coalition to first deal with fixing the unconstitutional sections of C-69 so that then we could move on to an analysis and assessment to ensure that legislators could deal properly with C-49 and would not be facing what obviously will be delays, uncertainty, and litigation even once this legislation passes. So this entire scenario is illuminating the failure on the part of the Liberal government to have not listened to experts in the first place in the Democratic debate on C-69, but also to have ignored us and held up this bill now while also creating this potential for uncertainty and litigation and even more lack of clarity for the people of Nova Scotia, Newfoundland, and Labrador, and for any private sector proponents who want to get involved in the offshore renewables as a result of Bill C-49. So kudos to the officials for being in an uncomfortable position and making good faith effort to answer these questions and deal with the mess that the elected Liberal members of Parliament have created for them, including, of course, backed by their NDP cohort. When we tried to deal with this in November, of course, the official is right that the C-49 was introduced on May 30th at the end of the spring session, always an indication of a government's priority, with, of course, no debate, no assessment by legislators at that time, and then only was brought back in September with less than 9 hours of total debate for all members of Parliament in all parties. And then, of course, we've heard from witness testimony through the limited hours that the NDP Liberals have forced on this piece of legislation that there are gaping holes both in the existing unconstitutionally, the C-69 provisions that are here, in C-49, and but what may end up being a catastrophic lack of consultation, the development of the bill with various entrepreneurs and business owners and generational family businesses in Nova Scotia and Newfoundland and Labrador. So I guess at this point, I would just like to say, imagine the time that could have been wasted. Imagine how much farther we would be ahead if the federal government, the federal Liberals, had just done the right thing in the first place, which would have been, first of all, to get C-69 right in the first place and not create a mess that has to be completely untangled now. But, of course, if they had just listened to us in November instead of playing games, delaying and delaying, to hold this bill up, we wouldn't have to be in this ridiculous scenario where we're having these conversations of having to bundle amendments to fix problems that are their own fault. Thanks, Chair.
Thank you, Ms. Stubbs. I'll now go to Mr. Angus.
Thank you. My understanding, officials, just getting myself back here onto ground zero on Earth, the push for this is coming from the provinces to update an existing accord, correct? We're not making something new. There's an accord. The provinces are pushing us to do this, so there's a timeline to get this thing done. Is that, did I misunderstand all this, or is that how this is playing out?
You're correct.
Okay, thank you. Well, then I'd say let's get it done, because that's what the provinces have asked us to do.
I think we've exhausted the speakers list. We'll now proceed to the vote. Shall G2 carry? Yes. If we could call the roll, please.
Mr. Aldag? Yes. Mr. Bruson?
Yes.
Mr. Batiste?
Yes.
Madame Lapointe?
Oui.
Mr. Sarbar?
Yes.
Mr. Dreesen?
No.
Mr. Tolmie?
No.
Mr. Patzer?
No.
Ms. Stubbs?
No.
Mr. Simard?
Oui.
Mr. Angus?
Yes.
7 yeas, 4 nays.
Clause 47 carries. Sorry, G2 carries. Yeah, we'll now go to the clause. Shall Clause 47 carry?
As amended.
As amended. Shall Clause 47 carry as amended?
Yes.
Call
Mr.
the roll.
Aldag? Yes. Mr. Bruson?
Yes.
Mr. Batiste?
Yes.
Madame Lapointe?
Oui.
Mr. Sarbar?
Yes.
Mr. Dreesen?
No.
Mr. Tolmie?
No.
Mr. Patzer?